Hi, greetings. It's me, Dr. Paul Gerhardt, and today I want to talk about job security and seniority. No matter what side of the table you're on, you really have to understand a little bit of history and make the best decisions possible for the majority of the stakeholders that are involved. And so in this video, we're going to talk about things like job security, seniority, calculation of seniority, promotions, layoffs, recall rights, advance notice of shutdown, determining eligibility, company mergers, employee teams, successorship, employee alcohol and drug testing, social media usage, and public sector security issues. Doesn't that sound like an exciting discussion that we're going to have? All right, so let's start off by talking about job security. Let's face it, employees need to feel like their jobs are successful. And you as a manager really benefit in the longer haul if you could help employees feel like they've got job security so that they can focus on doing a good job rather than feel like they have to constantly be looking for another job. And that's one of the things about unions is they help managers make the best decisions possible by creating processes that help them really think through making final decisions. It is often a shame when good employees feel like their jobs are always being threatened, and so they can't really concentrate on doing the best job possible because in the back of their mind they're always wondering if they're getting fired. And managers sometimes don't recognize that how they treat employees affects what they get. So having union contracts where there's very clear wording about job security and then the treatment of employees really can affect the overall success of organizations. You've probably heard me say, if you've watched other videos, there's got to be thinking win-win that matters in every situation. So workers truly demand jobs that have job security, and you don't want to lose employees to the competition. They're looking for guaranteed work. They're looking for the right to remain employed during times of layoff. They want to know about recall rights during times of layoffs, and then the right to a fair hearing in case of discipline. So there's something called industrial jurisprudence, and the system of rules and regulations that labor and management fashion to design their specific employment rights and obligation in the workplace. So ultimate labor management contracts really have words that help management free things up in the workplace and make things run more smoothly. Labor requires protection against unreasonable managers and a voice in decision making. It makes good sense to organizations when labor and management can work together to make decisions that benefit the organization as a whole. You've probably heard me say happy employees, generally speaking, not always, but generally speaking, will produce better. So sometimes, managers all the time are humans. And as humans, we are capable of making bad decisions. And good managers recognize that there are many different ways of doing things, and finding ways to support employees and treat employees with respect so they continue to feel like a valued member of the organization is absolutely important. So having management contracts and treatment of employees in a way that brings out the best of employees just truly is wise. There are theories used to justify staffing decisions based on seniority, like the human capital theory, implicit contract theory, internal labor market theory, and larger unions are able to negotiate more job security provisions. So let's talk about the seniority system first of all. This basically is a set of rules and procedures within an agreement that determine the allocation of certain job situations, including promotion, layoff, and recall, as well as has certain economic benefits based on the length of service. Seniority is the most important measure of employee job security, and it's easy to define in contracts and measure. So management would prefer to use performance appraisals as a base of employment decisions in most cases. And seniority is not required by law, nor is it an inherent right of employees. It just depends on the organization. It is mandatory in the contract language during collective bargaining. So here's how you calculate seniority. New employees generally begin acquiring seniority on the date and time of hiring, and seniority may not be awarded until the completion of a probationary period, usually speaking, unless contract language specifies otherwise. And so a seniority list is created to ensure complete agreement regarding seniority rights of employees. And usually human resource managers will have that type of documentation in their files, or if the organization doesn't have an HR department, the manager should have that specific information. Seniority rights vested within a variety of employee units. So even within each of the different teams, seniority truly may matter. So a lot of different ways of looking at seniority that kind of need to be that really do need to be specified. Is it plant-wide seniority? Is it departmental seniority? Is it class by classification? And how does bumping work? Bumping's about employees with greater seniority whose jobs have been phased out have the right to displace workers with less seniority if they are at least as qualified. And so again, as we're learning, we have to have real succinct, clear language with no assumptions in contract language. Seniority and the ADA, an example is the U.S. Airways Inc. versus Barnett. And an employee which specified that an employee is not entitled to a job assignment as reasonable accommodation of his disability if the assignment would conflict with the rules of a bona fide seniority system. So that's really important to understand. So precedence is one of those things when things come to court, it's up to each side to show precedence as it relates to making decisions. There's something called super seniority that I want to talk about here briefly, and that is special seniority rights granted to union officers, committee personnel that override ordinary seniority during times of layoff and recall situations in order to maintain active union representation within the company. With promotions, generally speaking, management's position usually disagrees with the seniority based on promotion. They usually contend that promotion should be based on performance and required skills, and they usually contend that promotions based on seniority takes away employee initiative. And we could go back and forth and argue that. Unless restricted by a contract, management can fill temporary vacancies. So most labor agreements use both seniority and qualifications jointly to determine promotions. Sometimes it's difficult to determine, weighting as a factor and methods of measuring skills and qualifications. And this is why seniority, which really is very, very clear, can be a method of being seen as being fair. Arbitrators hold that management has the right to judge, weigh, and determine qualifications as long as methods are fair and non-discriminatory. And in most disputed cases, the employer's decision usually is supported. Something called job bidding is done to minimize misunderstandings and grievances and to increase employee morale, which is a process that's detailed in the labor management agreement. So let's talk more about layoff and recall rights. Contract provisions that specify how seniority, ability, and other factors will be used to determine the order of employee temporary layoffs and job recalls truly need to be spelled out very clearly. If there's a probationary employees in place, they're usually laid off first. Is this what's going to happen according to the contract? And layoffs in skilled trades commonly occur by seniority within trades or other qualifications. Contract layoff procedures usually fall into three different categories. Layoff based entirely on seniority, layoff based on seniority employees based that management believes that are capable of performing the work, and then layoff based on seniority only if the ability and other factors are equal among affected employees. And of course, layoffs based on past performance. The firefighters local union 1784 versus Stotts, S-T-O-T-T-S, upheld a seniority system even though the resulting layoffs adversely affected employees hired under a consent decree to remedy past discrimination. Let's talk a little bit about the Worker Adjustment and Retraining Notification Act, or WARN, W-A-R-N, of 1988. It's commonly known as the Plant Closing Act, and WARN became effective in 1989, and it requires employers to provide 60 days of advance written notice to employees and communities of either a plant closing or a mass layoff. And it affects most private sector and nonprofit employers. And it gives communities and workers time to prepare. So let's talk about determining ability. Generally agreed that managers has the right to determine how ability is to be measured. Challenges to management determination of ability include employer has the burden of proof to show that a bypass senior employee is not competent for the job, and the employer is not required to show that a junior employee is more competent. Some other criteria used to determine employability may include experience, trial period, opinion of the supervisor, educational background, production records, attendance records, discipline records, attitude, physical fitness, and test. And again, as we talk about really being very clear, each of these things really should be defined in contracts. With company mergers, there are principles that are used to combine seniority lists. If you have Company A joining Company B, having clear language on what to do is probably very, very important. So you of course you want to do the right thing for the right reasons. And so you consider the surviving group principle, the length of service principle, following the work principle, the absolute rank principle, and then the ratio rank principle. With subcontracting and outsourcing, these are arrangements by an employer to have another firm make goods or perform work that could be accomplished by the employer's own unit employees, because the subcontract work can be done more efficiently or for less cost. Something called scope clause. This is what prohibits outsourcing bargaining unit work while any union member is in a layoff. With employee teams, employee involvement that creates an environment in which people have an impact on decision and acts that affect their workplace, not the terms and condition of their employment. The goal is to enhance productivity in three primary cases: decision making, problem solving, and of course creativity. Successorship is the status of collective bargaining between an employer and a union when a change in the ownership of the organization or change in the union occurs, and change in the employer. So that's successorship. With this, the court suggested 3 factors for application of successorship doctrine include substantial continuity, appropriate bargaining unit, and the predecessor's workers. So, successorship employer has several rights, including rights to hire its own workers, disregard the predecessor's collective bargaining agreement, set the initial terms of employment, and successor employer may be obligated to remedy unfair labor practices and grievances of the predecessor. Employee alcohol and drug testing. It's important to define this as a job security issue. So usually are concerned about unreliable or biased tests and then invasion of privacy. The NLRB ruled that drug testing is a mandatory thing that's subjective of bargaining. And testing job applicants who are not members of the bargaining union truly is a management right. So, management's desire to screen all job candidates may increase because of several different factors. The increased use of drugs within all segments of society, the reluctance of previous employers to report suspected or unknown drug usage of former employees for fear of litigation, and the employer's liability for the negligent hiring of employees. 6 common types of drug testing generally are used by employers. There's pre-employment testing, reasonable suspicion testing, routine fitness for duty testing, post-accident testing, random testing, follow-up to rehabilitation. So employees' attitudes during drug testing always should be a consideration. Random drug testing generally has aroused the strongest criticism, and unions insist on probable cause or accident-related programs for drug testing. So some negotiation issues there are the valid testing procedure, on-the-job impairment, refusal to be testing, and supervisor training. So these things really need to be spelled out in contracts. With social media using, employers in both private and public sectors are increasingly adopting policies to limit the use of social media both in and out of the workplace. The failure to follow such work rule can lead to suspension or even termination in many cases. Finally, public sector and security issues. So public unions and their members are often concerned that to lower their personnel costs, the government will turn to outsourcing full-time and public sector jobs. In the Great Recession of 2008, public sector unions were watching developments around the country as angry taxpayers complained about the size and expense of the government. So, all in all, employers really must be thinking about the big picture. What will be the impacts on employees related to job security and seniority issues? And you, no matter what your position are, how can you make sure that there's plenty of clarity and understanding based on precedents, based on contractual rights? In the longer run, both sides need to find ways to create added value to the organization and to the employees alike. Thank you so much for your valuable time. I'm trying to keep this under 20 minutes. Hope you found something of value in this video, and I hope that you have a great day, because only you get to choose how you feel about it. I'm Dr.